The Chief Justice has defended the decision to grant bail to persons charged with serious crimes, insisting that the prosecution can appeal such decisions. Brian Sykes added his voice to the controversy surrounding bail at a public education symposium in St. Andrew this morning. As Andrea Chisholm reports, the Justice Minister is also defending the judges.
There have been strong objections to update the Bail Act and deny bail to people facing gun and murder charges. The police have, however, supported the proposal, arguing that people on bail are committing crimes. Chief Justice Brian Sykes argues that several factors influence a judge's decision to grant bail.
These include, now not exhaustive now, risk of the defendant absconding, risk of the defendant interfering with the course of justice, preventing crime, preserving public order, and the necessity of detention to protect the defendant.
Chief Justice Sykes adds that under Section 10 of the Bail Act, if the prosecution disagrees with a decision to grant bail, it has the right to appeal.
The question is, has that provision been utilized by the Crown? And if so, how many times and with what results?
The law makes it clear that the prosecution can verbally indicate its intention to appeal the bail decision and is given 24 hours to provide written notice. The appeal has to begin within 72 hours, excluding weekends and public holidays, or a longer period considered appropriate by the court.
So, when we have persons making all sorts of pronouncements about judges granting bail, have they looked at the statute? More importantly, have they read the statute? And having read, have they sought to utilize the power given under the statute?
In the meantime, Justice Minister Delroy Chuck has also defended the judges, saying they have to balance the situation and consider all the facts.
So when the judge offers bail, it's not willy-nilly. It's oftentimes of the serious consideration of the time that the person has been in court, the charge against the accused, and the likelihood of the case being tried within a reasonable time.
Mr. Chuck is again urging the prosecution to put its case together in a timely manner. Andrea Chisholm, TVJ News.
Meanwhile, the Minister of National Security, Dr. Horace Chang, says the government is again willing to make changes to the anti-gang legislation. However, he says that will happen after the One Don gang trial ends and the outcome is assessed. The minister was addressing reporters in Spanish Town, St. Catherine yesterday during a tour of the area affected by violence.
We look even at what has happened so far, and if it's necessary to make further adjustment, we will do so, but we'll be advised. I won't comment on it until it's settled and we see what the judges have to say, because judges are the final interpreters of the law, and I don't want to anticipate anything they do, nor in fact interpret what they do. If the law requires amendment to get it more in line with the RICO Act of the United States, where a gang member can be prosecuted as a gang member, then we will have to do so.
The government already made changes to the legislation after the Uchen's Wilson gang trial ended.